Division 1 is now in session.
Thank you all. May be seated. Good morning and welcome to the students. We thank you for attending argument today. Hopefully it will be interesting. We are here for our case number CV25-0006, Moore versus Cottonwood et al. It's just a reminder to everybody in the courtroom, please silence your phones so that we can avoid any disruption or embarrassment. As the advocates are aware, we do record and live stream these proceedings, so please introduce yourselves and your clients when you stand up. You each have a maximum of 20 minutes for your arguments. You are not required to use all of that time, but you're welcome to if you'd like. It is your obligation to reserve any of that time that you would like to reserve for rebuttal, and the clocks are on the podium for that purpose. Please do keep in mind we have read the briefing, we have reviewed the record, we have conferenced the case, discussed it this morning. And with that, please proceed.
Thank you, Your Honor. Good morning. My name is Brandon Milan. I represent the city of Cottonwood in this lawsuit that pertains to a wrongful death lawsuit brought by the family of Miss Moore, who passed away in an unfortunate accident on Highway 279 near the city of Cottonwood. She was on her way to a friend's home late at night during a rainstorm and crossed over a low point in the roadway and unfortunately got trapped in the water and passed away. I represent the city of Cottonwood. The roadway is State Route 279 that we're talking about here. As we understand, it was constructed in or about 1955. As the name might suggest, it's a state route. The state abandoned the roadway statutorily under Title 18. As the court's aware, when the state abandons a roadway, it defers to the county, in this case, Yavapai County. Yavapai County was then the owner of that roadway in the area where this happened up until, we believe, today. However, there is an issue in this case that's obviously why we're here. In 1999, the city of Cottonwood annexed the area that includes where this roadway was. On the annexation, however, it didn't call out the right-of-way or the roadway itself. The county takes the position, of course, that the annexation actively transfers ownership over to the city. The city takes the position that without calling out the roadway in the annexation, it remains county roadway because that's how it defaulted to when the state abandoned it.
Do you have any authority for that?
I do. So if you look at ARS 9471, even the original version before it was amended in 2017, the accurate map and description that's used for annexation has to call out rights of way and the ownership of them. The map that's used here doesn't call it out at all. And so it's really a question of whether the court believes that's an active assumption of ownership or it defaults until it's called out as being owned by the city. And what I'm suggesting to the court is the map that was used in the annexation would have to say city owns SR 279 because it's annexing the roadway itself. I like to think of it as, for example, if the city of Scottsdale annexed roadway near the Loop 101.
But the statute doesn't say that, though, right? That you have to include roadways. Like if it's the state, isn't there a statute that sort of dictates how the state can sort of disclaim ownership?
The state can disclaim ownership.
Is there a statute to that effect?
There is. It's under Title 18. That's how the state...
And is there any equivalent, I'm sorry to interrupt you, for municipalities?
I'm not aware of one that exists for municipalities. I don't know that it would apply in these circumstances, however, because the state disclaimer statute is it owns the roadway and then it disclaims ownership or abandons it to the county. The situation here is whether ownership transferred from the county to the city upon annexation of the area. The annexation itself is what's at issue because in the annexation that was done, it doesn't call out that roadway. The ownership of the roadway is never actually determined through the annexation. That's what brings us here.
So you're saying that you can annex an entire area, but if a road is running through it, you don't annex the road unless you say you're annexing the road in the whatever the relevant documents are?
That's exactly what I'm saying. Yes, otherwise the city is essentially stealing property, right? It has to be able to tell the county, I'm taking your roadway and here it is in my annexation. If it's not, it's just annexing stuff and taking stuff away from people. It's my example is City of Scottsdale. They annexed roadway along the 101. Do they own the 101 now? Well, the federal government would have an issue with that, so would the state of Arizona. And that's kind of what the issue is here. If the city of Cottonwood says we're annexing the land and the right-of-way that the
Council,
county
if
owns.
it's omitted, then wouldn't we maybe look to then subsequent facts such as indicia of control?
I believe you would, and that's where the trial court went next. And that is where I think the dispute also lies, because the county had it on their maintenance schedule as of 2020, and they had signs along it. It's true that the city also had some painting along it, and that's why it was a question of fact where the ownership was never determined. Because you have both entities apparently believing either the other one owns it, or neither owns it, or they own it.
Does Yavapai posting signs saying that our maintenance ends here and then starts again after the annex portion mean nothing then?
Well, why would it be in their schedule for maintenance, though, in 2020, is what I would raise in response to that. I think it raises a question of fact at a minimum. And something that left unresolved because the trial court decided this as a matter of law, apparently, which I don't think it was able to do. You know, each of the cases that are being relied on here stand for the proposition that control can confer liability, but not in a circumstance where you have competing claims over ownership.
So you point to me, what evidence is there that the county exercised control?
Well, again, we have the signs, and then there's the 2020.
The sign that says Yavapai County ends here. You think that supports you?
I think it's important, yeah. They posted the sign. On the road.
Expressly disclaiming their responsibilities or, maintenance.
I mean, I could go out and post a sign and say I don't own my house. It doesn't mean I don't own it, right? The county's out there posting stuff along the roadway.
No, you're trying to use a sign as a positive piece of evidence to show control when the sign says, we don't control and we just want you to know that.
Right.
Okay.
I'm saying it.
What else? What other evidence?
There's a 2020 maintenance schedule that includes the area that was briefed in the underlying pleadings.
2020. Okay. So, was it just 2022 or is it
2020.
2020? Was it just 2020 or?
That's what was in the record, at least as far as I could tell. Yes.
Okay.
I'm sorry, is there any evidence they did? That there was work done in accordance with that schedule? I mean, the schedule itself.
Not in the underlying record, Your Honor.
Okay. Sorry, Dave.
But again, we're talking about the control, but we're omitting ownership still. WIGS, if you own something, it's a non-delegable duty. And it's not clear who owns the roadway because, again, we have the default to the county from the state, and then the city apparently annexes it without calling it out. If the county wanted the roadway for one way or another, I'm sure they would take issue with that.
What is your authority for the point that fee simple ownership determines liability in these road cases?
I would say WIGS versus City of Phoenix, the owner has a non-delegable duty, usually public entities. It's why if you represent a public entity, you can't say, well, I hired a landscaper to landscape the median and therefore I'm not liable. It's your median. You have to go pursue the landscaper for indemnity.
Right, so you're saying in that case, the municipality had a fee simple ownership of the road, and that was the reason the court found the way it found?
In City of Phoenix versus WIGS, yes, they were the owner of the area. I don't know if that was a roadway case, but it was a public.
Oh.
It was a public ownership item. It's a well-established maxim of law that if you're a public entity and you own a roadway or a public facility, you have a non-delegable duty to keep it safe or whatever, whether it's a sidewalk or a roadway, a transportation facility, et cetera. Now,
But I apologize.
You're fine.
Under State v. Reed, going back to your argument on the annexation, doesn't under State v. Reed land automatically vest to the city with title to streets?
I don't believe so, Your Honor. One, that case is...
Unless explicitly included, I guess, is excluded.
I think it's the other way around based on 9471.
But in Reed, though, do you recall the facts of Reed?
I do. You know, that's a 50-year-old case, 1, and 2, I think it would be contradictory to 9471, especially as amended in 2017.
Okay.
As it was amended in 2017, the legislature essentially clarified the point I'm making right now, which is that not only do you have to call out the roadways you are essentially taking from the county, but you have to specifically delineate and describe it there. Now, before that, that sentence wasn't there, but I think it gets to what I'm talking about right now is that, you know, the city can annex this building tomorrow and say it's theirs under what it is being proposed right now. No, the city has to be able to say, I'm taking this or give notice, et cetera. And that's kind of what gets us to what I'm trying to get at here. Now, I want to talk briefly, if I can. There's Martinez, Sanchez, and then there's the other case that's referenced for the proposition that control can establish liability. Yes, it can. But in each of those cases, what you're dealing with is you have just one public entity, not the other public entity, and the other one's not a party to it. And they're saying, well, I'm not the owner. I say, well, you controlled it so you can be liable. That's fine. But the Superior Court went one step further here with that because it found Yavapai County can't be liable. Well, if it's the owner, it can be liable. And that puts you in a position at trial where if there's evidence that Yavapai County had some sort of maintenance obligation or ownership under this roadway, you can't apportion fault to them now. And that wasn't an issue in those other cases. In fact, I believe it's Martinez. Martinez went to a verdict. And so it's a completely different appellate posture. Sanchez versus City of Tucson, there was an IGA, and only the City of Tucson portion was up on appeal. So the Superior Court didn't say, State of Arizona, you're not liable because of control. It just found the City of Tucson can be liable. That's fair. That's shared liability. That's fair. And I think that, again, an issue that we had in this case on the underlying decision that was made by the Superior Court.
So you mentioned two pieces of evidence to establish the exercise of control by the county. Anything more? What about that study?
There's the study, there's the maintenance, there's the signs, and then there's, of course, whether it's...
Does it matter that the study was in another location of the road?
I don't think it does. It shows they have ownership of the roadway itself.
All of it?
At least in the area, yeah. Especially if, again, the city can just annex and take people's stuff under the reading that I think is being pushed by the county right now. Again, if we were in a different posture right now, I think they'd have a different position on what we're talking about. I want to transition because I only have 8 minutes left, if that's okay, unless the panel has any additional questions. All right, so briefly, state-of-the-art defense. So it's not being contested that the roadway complied with the 1955 generally accepted engineering standards. That's step one. And it's not being contested that the defense put on evidence to support that through expert witness testimony. What the court found was that there was no evidence of notice provided to an unreasonably dangerous condition. It's the last sentence of subsection A. The difficulty here is that the lack of signage complies with the MUTCD to this day, and the lack of signage complied with the generally accepted engineering standard when the road was designed. That's issue one, because now we're imputing liability that contradicts the immunity statute in the first place. Two, there's no evidence that the roadway itself is an unreasonably dangerous condition. It was a rainstorm.
So, counsel, was this your motion for summary judgment that you made this argument?
Yes.
And that was denied, right?
The subsection A was denied, subsection B was granted, the trial has been bifurcated.
Okay, so how do we have jurisdiction over a denied motion for summary judgment?
There are cases that support where there is an immunity that has been taken away from a public entity. You do have a direct appellate right because there's no way to...
That's special action?
That is fair, Your Honor.
Did you use the word special action anywhere in your brief?
We cited to the cases that supported and used the direct appellate language for that because you do have a direct appeal right when an immunity is taken away from you. Otherwise, you have to try the case and appeal it later, and it defeats the point of the immunity.
So you say cases that were special actions, and that's your basis?
That's correct, Your Honor. The
Okay.
cases that support the prospect that even on the denial of a motion for summary judgment, you do have a direct appeal right when there's an immunity that's been taken away from you. The word special action, I agree, are not used in the briefing. However, I don't know that that is a requirement in the briefing for those words to be used. And if it is, obviously we're happy to file special action. But I think because of the direct appeal right that we have notwithstanding that, we are able to assert the argument.
Continue, sorry.
I don't have anything else to offer there. We're coming up on time. I would only offer that, again, the court's reading of the state-of-the-art defense contradicts the immunity because it's imposing notice requirements that are contrary to generally accepted engineering standards, which, again, is defeating the point of the immunity statute altogether. And with that, I reserve the rest of my time.
Thank you, counsel. Mr. Abney?
Yes. Good morning. May it please the court, my name is David Abney, representing the the plaintiff appellee, for a change, sorry. Sitting at council table with me is Suzanne Reed. She's representing the county. I'm not used to sharing my space with the defendant either, so I'm all frazzled. I've been finishing the Odyssey one more time, and I've reached the point where Odysseus has reached the land of the Phaeacians. It's the last stop before he goes to Ithaca. And of course he'll have trouble in Ithaca with all these people bothering his wife. And here we are basically at the land of the Phaeacians. This is the last stop before we get the opinion or memorandum decision. And with that brilliant segue, it seems to me the major issue, the controlling issue, is really control itself. You can be liable as a public entity if you simply control a specific piece of property or road.
Mr. Abney, could you help me? Is there a case of, to your colleague's point, that the cases on control did not involve sort of both parties present and competing over who had ownership?
I don't think they did, but I don't think it would make any difference. There's any, and I don't know if we cited any, but there's any number of cases that say people can jointly control property, and they're going to be jointly and severally liable as a result if there's any damage that occurs on the property. You don't have to own property to be liable for the consequences of failing to make sure that
But this
the
is a
property
different
safe.
posture in saying we're going to kick out one of the entities because we're going to find the other one had control. So it's not saying, you city have control so you can be liable. It's also saying, but you county are not liable. And if that's not the posture, is there a case that there is a similar posture
Not
with
that comes
competing
to
ownership?
mind. It
Okay.
seems to me that I thought, as I read through all the briefing and the record, I thought the posture was that both the county and the city could ultimately be found liable. Or the jury could say, on these facts, we find the city liable, but not the county, or we found the county liable, but not the city, or we find both liable and we assess percentages of fault, which is what the jury is supposed to be doing, assessing percentages of fault.
So, Mr. Abney, the city argues that the trial court erred because they made no finding of ownership. And my question to you is, did the Superior Court have to do that, given Arizona law, which I think talks more about control?
No, it didn't have to do that. Control is really what matters. If you control the property and something bad happens that you could have corrected or warned about, then you're going to be liable.
Well, so you have these, I'm sure you've probably been on many of these cases.
Yes.
Have you ever seen a court not really focus on the indicia of control and instead look at, fee simple or just, an ownership?
It all seems to come back to control. I mean, you talked about...
So you haven't seen any cases that have, what about Wiggs?
Well, Wiggs was interesting with streetlights, and did the city own the streetlights? And they didn't function properly, so the city's saying, we can't be blamed. And the court says, no, you can be blamed because it's a non-delegable duty. Of course, in other cases like Fort Lowell, the Supreme Court has explained non-delegable duty is really a misnomer. It's not exactly right. You can delegate the duty to maintain, for instance, a roadway, but what you can't delegate away is liability. You can say, I'm going to hire a company to maintain my streets. That's fine, but if something bad happens, you are liable. You've delegated the duty in a very real sense, but you cannot delegate away the liability.
So on annexation, should this court adopt a bright line rule that annexation of land automatically includes roadways within the annexed area, or should it remain a fact-intensive inquiry of indicia and actual control?
It should remain fact-intensive. This court deals in nuances. You know, each case is somewhat different from other, but to have a blanket rule that says you annex, liability changes forever, no. You have to look far further than that. You have to look about who's controlling this property, who's posting signs, who's maintaining it, who is making reports to all other entities in the area that we control this, we own it. And the city was doing a number of things. I mean, there's a list and a good discussion, I think, in our answering brief about all the things that the city had been doing, maintaining it, posting signs. They put a flood gauge there, monitored the traffic. They claimed control in the transportation master plan. They were talking about ownership and control. So it looks to me pretty solid that the city indeed controlled it. And if you control property, you're responsible. You have to do something to make sure that it's reasonably safe for the people that use it.
What about your colleague's argument on the maintenance schedule? Does that create an issue of fact? So he said
it may help create a dispute. And what we're talking about here is really, should you be granting summary judgment under these particular facts when there are disputes on key elements? And the answer is no, you should not be granting summary judgment. That's really where we are, I think. And you talked about the denial of a motion for summary judgment. I've run against that wall a couple times on appeals. And the last I remember was the rule was something like, you don't normally get to appeal from a denial of motion for summary judgment unless you have done some sort of post-trial motion to preserve the issue. I'm not quite sure how that works. Maybe a Rule 50 motion, 59, 60, well, I don't know. But that didn't happen here. So I mean, it really wasn't technically preserved. I hate making those kind of technical arguments, though, because I love to get to the merits. I think this court and the state benefit by actually delving into the merits whenever possible. But on the merits here, we have solid control. On the unreasonable dangerousness, I mean, this is, from the descriptions here, it sounds like this is a very unreasonable. It's a wide wash, a lot of water's going through it.
Is this the only area that remains for duty of fact-intensive inquiry?
Is this the only area?
Yeah.
No.
I mean, duty is a question of law.
You can say it's unreasonably dangerous? I don't think so, not here. Not here. Arizona's I was going to say Arizona is the only state where this happens, but it's in the Southwest in general, where you have the two worst things with traffic are dust storms and flash flooding. And some days you see them in the same day. You get hit with a nasty dust storm, and the next day you know it's raining cats and dogs and everything's flooded. It's something you really need to safeguard the public from. People can get complacent unless you put some signage up or maybe barricades, whatever it is you need to do, the nuts and bolts of how you deal with a particular situation. Here, a sign might have done it, and the presumption is, of course, that if you put a sign, people are going to read it and going to heed the sign. They don't always do that, but that's at least the presumption, and there's nothing here to go against that presumption. I'd like to save my time. My colleague said, I heard you're a talker. Can you be sure to save half the time? So I'd be glad to talk some more because I am a talker, but no further questions? Thank you so much for your attention. It's always a pleasure.
May it please the court, I am Suzanne Reed on behalf of the Winnicke Law Group representing appellees Yavapai County and Yavapai County Flood District Control. The issue before the court is a straightforward legal issue. Who had a duty to maintain Old State Route 279 on July 24th, 2021? Here, the lower court analyzed the undisputed facts, applied case law, and determined that it was the city of Cottonwood and not Yavapai, and granted summary judgment in favor of Yavapai and denied Cottonwood summary judgment. We ask that you affirm this decision. Now, Cottonwood has brought up a lot of different arguments that I would like to address to make sure the record is clear here. So the undisputed facts are that, correct, in 1999, the city of Cottonwood annexed over 3,000 acres of land. So they expanded their boundaries. What happened at that point, though, is that they did not exclude this roadway. So what has happened since then?
What do you do with counsel's argument that in order to have gotten the roadway, they had to include it? Is he correct that under the statute, in order for the city to have ownership over the road, they would have had to include it?
Well, actually, his argument actually goes against what City of Cottonwood's own maintenance, their general plan says regarding annexation. They say that annexation includes maintenance of the roadways. What he is citing to is actually something that occurred after this annexation where there should be a description of who maintains the roadway. Annexation means you are taking the land.
But Judge Perkins' question, just following up on it, is it including or excluding? When you annex it, I mean, because I read cases that said you need to exclude it. You need to say, we're annexing this area, but excluding the road. And your colleague says it's the opposite of that. Which is correct?
Well, the statute says that they can name the right-of-ways. No right-of-ways were named here. So they didn't say this was a county right-of-way. So the assumption is they took that roadway because combined with the actual act of annexation, what did they do? Well, they maintained the roadway. They actually included in their maintenance contracts. They striped the roadway at least 7 times. They put up no dumping signs. They had the low flood gauge signs. They included in their traffic inventories. They actually included in their generalization plan, where it's part of, called a city street. When they did their bike ordinance, again, they called it a city street. When they were part of the Valley Verde transportation plan, they called it a city street. And we're one of the agencies that said the pavement should be renewed here. So City of Cottonwood cites to WIGS. And I want to say that WIGS is actually distinguishable. That is where the City of Phoenix hired a third party. No one's hired each other here in this case. There are 2 different jurisdictions. So it is absolutely distinguishable. He also refers to a study that occurred. That was because Cottonwood asked for the Yavapai County to partake in that study. This is very common. It happens when bigger jurisdictions who have the engineers, who also have other roadways that could be influenced by what occurs, will participate in a study. That does not mean they control or maintain.
Can I ask you the same question I asked Mr. Abney, which is, should this court adopt a bright line rule that annexation is enough, or is it still that fact-intensive inquiry?
I believe it's still a fact-intensive inquiry for 2 reasons. The annexation statute says that there should be a description of what is annexed, and that should include roadways, or exclude roadways if that's not included. Arizona case law says, though, but let's look at who controls. Arizona also looks at the restatement of torts, which says control is the main issue. So specifically in their statement of torts, we look to Section 349, comment B. It's the duty placed on the municipal subdivision which holds the highway open to the public for travel. They have the duty to maintain and duty to warn. Over and over again, the cases that have been referred to, Sanchez, Martinez, City of Cottonwood, talk about how we follow torts second edition. So we look to the actual facts of who had the duty based on who controlled it, who took responsibility, and that makes sense. So for example, if there was an annexation here and Cottonwood did not do anything for the last 20 years, and there would be an issue. But here the undisputed facts are they did everything. They maintained, they striped, they included it in their inventories. What did Yavapai County do? Well, they didn't include it in their highway user fund report. That's how they get money for roads. Council also mentioned that there were signs. Yes, these signs said Yavapai County ends and begins, which does not include this area whatsoever. So saying that we don't own this, and in fact we maintain other areas, which you can see by the coloration, doesn't all of a sudden mean that we now maintain this area that you annexed. Absolutely not.
Sorry to interrupt, but what about your colleague's argument that it was in your 2000 maintenance schedule, I guess, this wash?
I would like to ask where that is in the record. In 2020, I think, did he say 20? I thought he said 2020. He said 2000?
2020, I think.
Okay. In 2020, City of Cottonwood reached out and said, hey, Yavapai, in a different area of Old State Route 279, let's do a stop sign study, which our expert, Andrew Kwasnowski, I say his name wrong every single time, talks about how under the guidelines, that's normal, because they will participate in such studies. But what the county did is said, we will help you with this, but these are not our signs. We're not maintaining this area. This is also not in the area of WASH. So that doesn't mean that all of a sudden there's now some type of control of a different area within the state route. So the county, and Judge, I don't mean to interrupt, the county does maintain a very small portion south of this. It's a quarter of a mile. This area is kind of jigsaw puzzle-like. So there's different boundaries for sure. But what is very clear is that this particular area, Christina Draw Wash, was within the city of Cottonwood's boundaries. That's also clear because the geographical information system that tells you what parcels are. That's how the city engineers know what roadways are. It identified at this time, when this occurred, that this was a city of Cottonwood roadway. So everything points to Cottonwood for 20 years. And now when something happens, Cottonwood says, oh, it's not us. There might be confusion, it's not us. That's not how it works. According to the restatement, according to case law, we look at what the control is. And whoever exercises that control has the duty to maintain it, to make sure it's safe. Additionally, Cottonwood cited two amendments after the fact regarding the annexation statute. That has no correlation here regarding what occurred in 1999. Again, Cottonwood, I've mentioned several times about how they maintain it. They include it in their traffic counts. They're part of the Verde Valley Master Transportation Plan. They include it there as a roadway. Cottonwood Bicycle Plan included as a roadway. Cottonwood General Plan included as a city street. The maintenance contracts from 2002 through 2023 included it as a street for them. The road inventories. So over and over again, the city of Cottonwood has shown its ownership through its duty. There is no case law that says there has to be a legal transfer of title for these types of roadway cases. The duty is placed on the government jurisdiction who takes control. So we have the two acts, the annexation that does not exclude this actual route, and then we have, for 20 years, the ownership through maintaining responsibility, maintaining that roadway, having that duty. And I think at this point, no party is saying that the Yavapai County Flood Control District is part of this. I just want to say for the record, they only do unincorporated portions, so they're not part of this whatsoever. But Yavapai County, in contrast, has not done anything. They stopped maintaining it. Being part of a joint coalition to talk about a traffic sign is not equal maintaining it, especially when it's not even the area. They put up signs saying where their jurisdiction begins and ends. There's a clear difference in the pavement when they actually do maintain their portion of the roadway. That's not in this area. And finally, the plaintiff fully admits that Yavapai County did not maintain this, and this is not part of their inventory. So based on the record here, the undisputed facts, over and over again, the city of Cottonwood showed that they had a duty here. And that was the sole question of the motion for summary judgment. And based on case law, based on the restatement, the answer is the city of Cottonwood. And unless the court has any other questions, we did not brief the other issue regarding immunity. Thank you, Your Honor.
Thank you.
I want to start by reading a quote that is in the record, and then I'll get to the arguments that were just given to us. This is from Yavapai County's Public Works Director. It says, quote, further, that while platted roadways automatically transfer in an annexation, fee title roadways do not, and we were not able to find a document that specifically transfers this to the city of Cottonwood when it annexed this area in 1999. Therefore, this roadway remains a non-maintained Yavapai County roadway at this time. That's as of 2017.
Was that in your brief?
It was in my opening brief.
Your opening. So that's a fourth piece of evidence.
Correct. It's an admission by the county that they don't maintain the roadway they own. So If we tried this case, and I was here.
The statement was they don't maintain it. So they
Exactly.
don't exercise control over it, but they still own it.
Correct. That's 100% correct. Based on that statement, it's a non-maintained county roadway. I don't know that maintenance means control in that circumstance, but I agree with what you just said there. So if we had tried this case, and I was upset that I had apportionment of some amount of fault and Yavapai County got a defense verdict, I would understand her argument, but we're at summary judgment. The court made a legal determination that the Yavapai County, despite potentially being the owner, at least in dispute of fact, cannot be held liable in this case. And that's really what brings us here, is that if we try the case, I can't apportion fault to the county despite them being the owner of the facility. And that doesn't make any sense. All of the cases stand for the same proposition that I have just said to you here, which is that the owner is potentially liable, especially in Wiggs and also Beach. I remembered Beach as I was sitting at my chair right there, Beach versus City of Phoenix. That's the one about the trees and the sidewalk. Sidewalks are transportation facilities, same idea. It's the case that you cite in every trip and fall case if you defend public entities, the quarter inch ADA thing. So with that, the distinction that was made on delegating duties by council for Wiggs was the idea of delegating to a subcontractor or whatever. That's the example I gave about a landscaper and a median. In that circumstance, typically, yes, it's my median, therefore I'm liable, and then I get indemnification. I can't do that here. That's what brings us here. You know, I would give a quick example on the ownership versus control issue. I'm sure this court's done construction disputes, the Pay Act. If I'm the owner of a project and the general contractor has control of the project, is the general contractor solely liable, or can the owner be liable because it's their project? Well, it's the same sort of idea. Owner indemnifies down, up, up. It's the same idea here. So that's how I would distinguish those cases. On the other thing I would point out is council brought up the GIS mapping. This is another question of fact.
Can I just ask you, did your 30B6 witness testify that you wouldn't have no dumping steins, install flood gauges, and conduct traffic studies on roads you don't own?
If that's what the quote says, that's what it says, Your Honor.
Okay.
I want to point out one thing for the record, too, because it's in the brief, but it wasn't cited correctly. If you go to IRA 80, paragraph 23, there's a printout of the GIS mapping for this area, and it shows that Yavapai County Public Works owns the roadway in this area. And that was used in the controverting statement of facts in the summary judgment motion. Now, again, am I saying that to you as it's a fact and therefore Yavapai County is 100% liable? No, that's a jury question. That's my point, is everything here are things that juries are supposed to be considering, not the court on summary judgment. In fact, if you read the minute entry, the first 3 or 4 pages are about weighing evidence. And it says it's clear that the evidence shows City of Cottonwood controls. Then you go 4 or 5 pages later, well, the court can't weigh evidence. That's not our function. That's the jury's function. Well, it's kind of a contradiction of itself there. And so that would be what I have on that issue, if the court has additional questions. On the immunity issue, I have never seen what Mr. Abney referred to in the post-trial motion on the direct appeal right. I have always understood it that if an immunity is taken away, you do have the direct appeal right, because that's the point of the immunity. So I would only just reiterate that. And I'm sure I didn't say anything else. Also on the immunity thing, when we talk about the signs, Mr. Abney mentioned a presumption that people read signs and therefore potentially adhere to them. As I recall, the evidence showed here that the young woman that passed away actually sped up into the flood, not stopped because of it. The other issue is, again, the MUTCD doesn't require signs for this kind of roadway. It's optional or guidance. And there's a case in the Ninth Circuit, it's McKay versus City of Tucson, that deals with that issue, where expert affidavits assigning things that are not required can't create questions of fact in traffic control cases. And so I would just point the court to that case. And unless the court has additional questions, I have nothing further.
Thank you, counsel. Thank you for your arguments and briefs. We will take the matter under advisement and issue a decision in due course, and we will stand in recess to reset for the next argument.